Just a couch at a place in the suburbs? No, not by a long shot.
Oh, wow.
The police reaction. Seeing the secret entrance revealed to a gun lover's treasure trove. Officers finding a range of weapons at the property, handguns, shotguns, more than 1,000 rounds of ammunition, plus a workbench equipped to modify firearms. Even an underground shooting range, complete with pulley system to set the target. The stash also included a .50 caliber rifle with ammo, a weapon designed to penetrate armoured vehicles, even buildings.
We also found a suppressors, which are like a silencer, that's illegal. Body armour, illegal. Unsecured ammunition and unlicensed ammunition, illegal.
Fifth Circuit rules against the plaintiffs in a suppressor lawsuit against the NFA, but not for the reasons you would think. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like channel, like content, and what I do, you can support me with the link. Everything is appreciated. Once again, PSA, if your comment disappears, I'm not doing it. This is a growing problem on this platform, where comments are being removed without any notification or reasoning, and it's specific comments, specific channels, specific content. So if it disappears, I'm not doing it. Let's talk about this. Now, the Fifth Circuit Court 3-judge panel handed down a ruling on the case of Paxton versus Dettlebach. This is concerning the NFA and the registration of suppressors, silencers, whichever one you want to call it. But the Fifth Circuit ruled against the plaintiffs, which is Attorney General Paxton and 3 other additional plaintiffs, but not on the merits of the case, but on the standing. This court stated that they do not have standing to bring this case. Let me give you a little information here, because this is from their opinion. First, the declarations do not state any intention to engage in conduct prescribed by law. Rather, the declarations state only that the individual plaintiffs intend to personally manufacture a firearm suppressor for their own non-commercial personal use. But as the federal government points out, the statutes at issue do not prohibit the individual plaintiffs from making a firearm suppressor. Rather, they only prohibit making a firearm suppressor without complying with the applicable procedures and requirements, i.e., applying for approval, paying the requisite tax, registering the suppressor, and labeling it with a serial number. This is a distinction with an important difference, because it differentiates this case from those in which the statutory scheme at issue is a blanket prohibition. What they're saying there is, okay, you haven't done anything yet. What you got to do is you have to make a silencer, submit your Form 1, refuse to pay the money, the $200 tax stamp, and then it could say you're doing it under protest. Then your case basically now has standing. But they did not bring this case to the court with that intention. Now, don't get me wrong, I think suppressors under the NFA is ridiculous. I think silencers and suppressors should be treated exactly as firearms. You go through a background check, you do your 4473 for that specific item, and that's the end of it. I don't think you have to go to the federal government to get approval on it. But what these people are doing here, they're saying, we're going to make a silencer. I'm going to make my own silencer for my use. I'm not selling it non-commercial. I'm not selling it to nobody. It's not going to be transferred to no one. It's for me. I'm using it. I don't think I have to pay the tax. The court is saying, well, you haven't done that. You didn't do that, so you don't have standing. So this case is not being overruled based on the merits of the case itself, but on the fact that they don't have standing to bring this case before the court. Now, A.G. Paxton, Attorney General out there, Texas, we're waiting to see if he's going to refile this, or if they're going to, these plaintiffs are going to make a silencer and submit the Form 1 without paying the tax, and then they have a foothold in bringing this back to the courts. But this is not a setback. It's not a setback. All it is the court doing correctly what they're supposed to do. But as I stated, I don't think silencers should be, even short-barreled rifles should not be under NFA. They should be treated as regular, as you would with a regular firearm that you would go into the store and buy. That's my opinion on that, because it doesn't change anything. But I want to read this part here. This is the analysis of the author of this article. This case is one of several attacks on the viability of keeping silencer suppressors subject to National Firearms Act regulation. Aside from the obvious constitutional questions, such regulation does not make any sense. The regulation is counterproductive and produces more harm than any of the known benefits. Actual criminal use of silencers for violent purposes is extremely rare. I have never really heard of anyone using a silencer for criminal activity. I've never heard of that. I'm sure it may have happened, but it has not been a very prominent story in the media. So the 1986 ban on silencer parts is based on a foundation of lies. There is a push to make obtaining legal silencers easier, either by reforming the NFA or by removing silencers from the NFA. I'd rather they just remove silencers from the NFA, but if they're going to reform the NFA when it comes to silencers and short barrel rifles, it shouldn't take 3 to 6 to 9 months for them to do it. It shouldn't take that long. That's my thought on that. But so there it is, and it's just an interesting case because it's just another one of these things that's going around the court system right now that we should be paying attention to, because once again, this affects all of us. Because some states do not allow silencers, California being one of the biggest, New York. But this could very easily change with law, because it's state law, you know, especially if you live in a state that has a very left-leaning government. This could change very easily. So cases like these are very important, especially when it comes to the NFA, because remember, they were trying to put any firearm with an arm brace and a barrel below 16 inches, they were trying to put it on the NFA also. So this is just another case that needs to be watched very closely. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'm going to see you on the next one. Peace.